well, I've got 7:01, so I think we need to get started.
Yep.
This is the Board of Selectmen's meeting for Thursday, December 10th, 2020. Pursuant to Governor Baker's order suspending certain provisions of the open meeting law, General Law, Chapter 30A, Section 18. This public meeting of the Town of Bolton Board of Selectmen is being conducted via remote participation. No in-person attendance of members of the public will be permitted, but the public can access this meeting while in progress by Zoom Video Communications, Inc. A couple of guidelines about participating in the meeting. Let me get my notes so I get to all of them. First off, you do not have to post your name on your Zoom identification in order to observe the meeting. But if you want to comment or ask a question, you will then have to identify yourself at the beginning of your comment or question. If you'd like to, the easiest thing to do is to go down to the participant. If you want to raise your hand on Zoom, that's a feature that's available down in the participants section. Open that up and you'll see in the lower right hand, it says raise hand. What I'm hoping is that Jonathan Keep joins us, in which case he will be watching the chat room for questions. But is Jonathan here? Okay. But if you want to use the chat room for a question, you need to identify yourself either through your identity that's posted on Zoom, or you'll have to type in your name in order to be identified with your question. First on our agenda is a review of and comments for the Lovecraft Host Community Agreement. I would like to just point out that if you read it, there were a couple of typos in there. Most of them have no significance except one in section 18, where it says the Court of Competent Jurisdiction in Hampden County. That will be changed to Worcester County, as neither Bolton is not in Hampden County. We thought it might be helpful for people to put tonight's meeting in perspective if we had Town Council, Mr. Brian Falk, come and describe how tonight's events would fit into what's the order of, or the sequence of events of things that could happen after or as a consequence of tonight's meeting. So at this point, I'd like to welcome Mr. Falk and turn it over to him.
Thank you, Mr. Chairman. Again, Brian Falk from Myrick O'Connell, Town Council. Please wave if you can't hear me, if the audio cuts out, or if you have any connection issues in hearing me. My broadband doesn't always work that well. So the Board of Selectmen, having received a presentation from this applicant, Lovecraft, asked myself and the town administrator to negotiate Lovecraft a host community agreement, which would allow them to start the process of siting a marijuana facility at this location. The host community agreement stage is just about the earliest stage in the public process. The applicant can't even apply for a license with the State Cannabis Control Commission without a local host community agreement. This is step one, and the Board of Selectmen's authority to enter an agreement or not enter an agreement. And tonight we're bringing back to the board the draft of the agreement that the town administrator and I negotiated with Lovecraft for the board to review, to comment on, and to decide whether or not they want to enter, whether they want to consider it further, or whether they want to send us back to the negotiating table. Assuming a host community agreement is entered at some point in time, again, this is the earliest phase of the process. Lovecraft would then likely apply for a license with the Cannabis Control Commission. And at some point during that licensing, will likely apply for special permit and site plan approval from the town's planning board. The planning board would be holding a public hearing, probably a series of public hearings on the application if it comes in. And abutters would get notice of that public hearing and have an opportunity to be heard on issues of importance to them with respect to the project. Assuming there's a host community agreement and assuming there is a special permit, a site plan approval that survives appeal, then the applicant would be able to get a final license from the Cannabis Control Commission and eventually open the facility. So again, we're at the very early stages in this public process. And we're at the stage now where the Board of Selectmen is considering the draft of an agreement that's been negotiated with the applicant to see if the board is inclined to move forward or if there's more work to be done.
Thank you, Mr. Falk. At this point, I'd like to ask the other selectmen if they have any comments or questions.
Yes, Mr. Chairman, I do. I had provided Mr. Lowe with some comments on the agreement, and I believe Mr. Lowe had forwarded them to our town council. Brian, have you received that document with my comments?
Yes,
Okay.
I have.
All right, well, let me, maybe I'll just go through them sort of in order within the document itself. I had about 3 or so, and then also Mark Sprague had communicated with me and provided some comments, and I included those at the end. Going to specifically Section 7, scope of the facility, and Section 7C, which states full build out of the facility and all of its component uses, retail, product manufacturing, and cultivation, shall be completed within 3 years of the effective date, and the facility shall be limited to those components in place and operating within 3 years of the effective date. The paragraph ends with, unless this deadline is extended in writing by the Board of Selectmen. Since this is an initial HCA, and that's what I just had stated is what we wish the intent to be. What I had written in the comment section, and I'll just read it verbatim. It says, I'm strongly opposed to allow for any extension of the deadline in this section, but in the wording needs to be a bit stronger here for Lovecraft to provide detailed justification for the extension, the impact it might have on successor HCAs, and our ability to deny or extend or just remove the highlighted text, which would be my preference. I actually would prefer to have the wording, unless this deadline is extended in writing by the Board of Selectmen. The intent is that the applicant has come before us with a proposal to have retail, product manufacturing, and cultivation at this facility. And that should be the intent, and that should be the goal. And we should put a reasonable deadline, which I believe is 3 years from the effective date, and not include a statement that says unless this deadline is extended by the Board of Selectmen. I don't think we should have that extension. It should be 3 years or nothing, in my view. Moving on.
Dan, pardon me for 1 second, if you don't mind.
Sure.
Mr. Chairman, we just need to notify the public and all the attendees that this meeting is being recorded.
Oh, thank you.
Sorry.
Okay, great. All right, moving on to Section 8, which is site and facility operations, and specifically item C, which is other uses, tenants, and subtenants. The way that the paragraph is reading now is the site shall not contain any uses other than the facility, and no tenants or subtenants shall be allowed to operate at the site unless this restriction is modified or waived in writing by the Board of Selectmen. I think it would be detrimental for the town to have a provision that would potentially allow any subletting of the facility. Given what we just discussed, or I just discussed in 7C above, we want the applicant to be fully operational with all the aspects of what the applicant is planning for within 3 years. If at any point in time we allow the applicant to sublet any portion of that facility, that puts that whole timeline in jeopardy. I think for this initial HCA, that's what the applicant wants to do. He wants to have those particular business items at that facility. And that we should not be allowing any tenants or any subletting of that facility that could potentially derail that. As I wrote in my comment, and I'll just read it verbatim, as this is the first HCA and we want Lovecraft to get their business to its final stage with all the components as defined in section 7C within the first 3 years of this initial 5-year HCA. Having a provision to be able to potentially modify or lift this restriction is contrary to that goal. I would want the noted text removed from the agreement. There should not be any ability for Lovecraft to sublease the buildings for any reason during that period. The next item that I have is all the way down. All right, in section 14, term and termination. Item 14B, it says, unless terminated, this agreement shall continue in effect until a final community impact fee payment is accepted by the town, covering gross sales for the final 6 months of the company's 5th year of operation of the facility following the opening date, such that the company's obligation to make the community impact fee payments should not be effective for more than 5 years, which is the term. My comment is the agreement should remain in effect, but operations should cease when the final community impact fee is due, but not remitted to the town. And in item 14C, the text in the agreement says, upon the 4th anniversary of the opening date, the parties shall negotiate in good faith a new host agreement to succeed this agreement unless such a successor agreement is prohibited by law. I'll just read my comments verbatim. Given the conditions described in section 7C, which is full build out of the facility and all its components and uses, retail product manufacturing and cultivation, which shall be completed within 3 years of the effective date, and the facility shall be limited to those components in place and operating within 3 years of the effective date. If this has not been met, there should not be any start to negotiating a new host community agreement. Negotiation of a successor HCA should only take place if Lovecraft has completed full build out of the facility as described in section 7C. So the way it's reading here, regardless of what happens, we're going to start a renegotiation of a new HCA in the 4th year. And I think there should be conditions in place that stipulate why the renegotiations should take place. And that should be the completion of what was described in section 7C. I did have a question. If we do move forward with a successor HCA, can a successor HCA be executed that is less than 5 years in duration, if there's some extenuating circumstance? And in section 15, successors and assignment. At first, I was not necessarily agreeable that this agreement should be allowed to be transferred in any manner, but in lieu of that, my comment is I would argue that 15 days is far too short for the town to identify any concerns with the prospective assignee, because in that section it says that if the company wants to assign this to a successor due to a variety of reasons, the town would have 15 days to determine whether or not that the prospective assignee is worthy of that. We would need a longer period of time for our due diligence. Can I assume that Lovecraft would need to get the okay from the Commonwealth first? So one is I would like the period of time to be extended, something longer than 15 days. I don't think that's enough to do our due diligence. I would like at least perhaps 30 or 60 days. And then I would also want to know from town council, would Lovecraft need to get the okay from the Commonwealth first before they would approach the town on this particular matter? And that's it for me. And then obviously I included at the end of the document some comments from Mark Sprague. We can allow town council to comment on those. That's all I have.
All right, Brian, can you address Stan's specific question?
Sure. So the specific question was whether we can do a host community agreement for less than 5 years. And the answer is yes. The 5-year timing is significant because that's the maximum length of time that a host community agreement can impose a community impact fee. A host community agreement can be, indefinite as long as the facility is open, but the impact fee can only be for 5 years. This is all relatively new in terms of having these facilities. We don't know yet what happens after 5 years of the impact fee. It's not clear in the statute. The Cannabis Control Commission hasn't put out an opinion on that point. And so by and large, host community agreements are stop at 5 years so that there's a renegotiation so that the fee gets re-upped with a new agreement and there's a new 5-year period. If we just leave the agreement, indefinite, and the 5-year period goes, then the impact fee in theory would go away and the town wouldn't have the opportunity to go back and renegotiate for an impact fee. But a term of less than 5 years, that's permissible, absolutely.
Okay.
So what you're implying there is that if we don't put something in this agreement stipulating that both sides will negotiate, there could perhaps be no new host community agreement. The existing one would remain, except there'd be no remuneration.
That is a possible scenario and not one that we want for the town. So the almost every host community agreement I've done and most other towns have done, it's a 5-year agreement with a renegotiation specifically with that impact fee in mind, that there will be a new 5-year period. And again, it's drafted with the uncertainty in the statute in mind, because we don't really know how this is all going to shake out when the 5-year period is up, because the law is unclear right now.
Right.
Okay.
Well, the intent of the intent of my question was not necessarily for this one.
Yeah.
But obviously what my suggestions for changes to this agreement are to tighten things up. But for whatever reason, if we get to some period where we need to negotiate a successor agreement and perhaps not everything is done, that we wouldn't necessarily have to negotiate yet another 5-year agreement. We could say, okay, you've got 1 more year to finish up whatever you need to do as a successor agreement. So that was the intent of my question.
Yeah, that's correct.
Okay.
Jonathan, any questions or comments? Jonathan, you have to unmute yourself.
Sorry. I am unmuted. Can you hear me?
Yes.
Yes.
Okay. Number 8, page 4, about 8B, site access. It says the company shall modify the site so that access and egress is limited to 117, and the site's access to Bolton Woods Way shall be permanently closed and gated, with access and egress only available to emergency vehicles unless this restriction is modified or waived by the Board of Selectmen. So this just seems a little vague. My understanding, or I'm interested in closing off almost all of the access from Bolton Woods Way without gates, permanently removing the asphalt landscaping to create a buffer between the business and the residential road, leaving the back access to the back of the building with the gate. So I'd like to see more definite language about this rather than having kind of 4 gates along there. I'd really like to see a separation between the two.
So your objection is not that we're leaving one available for emergency, it's that we're not specifying what should be done with the other spaces?
Yeah, yep.
Okay. Okay.
Well, actually, wouldn't that be something that would be part of the special permit process? in
It
terms
could
of
be, or we
detail.
could deal with it here. It's up to the Board of Selectmen if we want it to occur there or here. I mean,
Yeah.
if we dealt with it here, further changes would not be prohibited in the special permit process.
That's correct.
Right.
So yeah, that's just an important issue to me. I think it's very important to create that separation between the residential and the business. Right now, it's very porous.
Well, actually, I think cutting off any ingress and egress totally, I think proposes more of a safety hazard than not.
But he's
And-
not doing that, Stan. He wants to allow the emergency opening. And it's just the other ones off of 117 he wants to permanently close, as I understand Jonathan's proposal.
I believe there are 4 or 5 access routes from Bolton Woods Way into the site. And it's my understanding that the fire chief would like to keep one open to the back of the building, but the other ones to the front parking lot are not necessary. And so it just seems important to remove those and create a separation between the residential and the commercial.
Well, that's fine, but that's not exactly what it's saying in that paragraph. So you need to.
Right, I'm proposing a change, Stan.
I understand, but you need to specify exactly which ingress and egress you want removed. It's got to be specified.
I think he's given us enough clarity on that one. I mean, he's referenced the far back one as the one to remain as the
Okay,
safety entrance. And so I think we can work with that.
okay, that's fine.
I don't have any additional items beyond what Stan and Jonathan have brought forward. I'm going to kind of walk through the two of them. I'm starting on 7C. I'm reading it, and do we want, unless this deadline is extended in writing by the Board of Selectmen. And the effective date is, when is the effective date, Brian?
The date of the agreement. The date we enter the agreement is the
Okay.
effective.
So that's 3 years from when we enter this agreement, but then he's going to lose months, if not a year, going to the Cannabis Commission and other things there, right?
The speed by which he gets permits and licenses, I can't say. Cannabis Control Commission, it's roughly a year now, but they have sped up quite a bit processing of licenses, so it might not be that long.
Okay,
And the planning board process, it varies by application.
okay. And then what was the one on eight, other uses, tenants and subtenants? Was that your change on 8, Stan?
7C was the one we just discussed.
Yeah,
8C.
yeah. I'm okay with taking out the modification by the Board of Selectmen there. I'm just staring at 7C. I kind of go back and forth on 7C.
If I may, if it's helpful, because 7C and 8C are similar concept that Stan has raised, and it's a different approach. And to my mind, both are valid, and we can draft an agreement that works both ways. Our goal with this, with some of the issues, because again, we're at the very early stage of this project, things are still being determined on the applicant side and on the town side. And so, we flagged a number of issues, and we don't necessarily have resolutions or clarity on those issues now, but we wanted to come up with a framework by which both parties could move forward. And so the goal with these was to give the parties flexibility to address specific issues without amending the agreement, but putting the Board of Selectmen in the driver's seat. None of these are by mutual agreement. None of these are not to be unreasonably withheld. They're all in, it's up to the board to waive these or not, with total discretion whether to waive these or not. And so having it there, it would give the board the opportunity to waive. Not having them there, if a proposal came in and said, look, we're going to be 3 years and 2 months past our deadline. That's the way it's going to shake out. We'll be in violation in another month. Will you amend this agreement or not? And if the board says no, then the applicant would be in breach of the agreement, and consequences could ensue. Having the waiver language there allows, we don't have to reopen the agreement and put anything else on the table. We can just deal with this one discrete issue through a selectman's waiver. And that's one approach, the one that we took to put the board in the driver's seat and to allow some flexibility as the project develops. Another approach, and the one Stan has put forward on these two provisions, is to say we have deadlines and that's what they are. And these are, and we have on 8C, we're not allowing subtenants and other uses, period. If that's going to change, we need to amend the agreement. And that's a perfectly valid approach. It's just one that if there is going to be a change, it requires amending the agreement, which can be a bit more cumbersome than just the board taking up a waiver request at a meeting.
Well, on 7C, if the selectmen modify or waive the requirement, could they just set a new date? Like, we'll give you 3 months and then you're in violation, or we'll give you 6 weeks or something like that? Just basically just set a new date and then everything else is intact just with that new date?
Correct. The board issues a letter with the new date, and the agreement, would be in violation if we go beyond that new date. I've done exactly that, not on this type of a provision, but on a permitting schedule provision in a host community agreement for another community where, the applicant ran up against the 6-month clock that they have, and they asked for another 3 months, and the board there issued a letter extending it by 3 months, and that's how they resolved it. They didn't have to amend the agreement, and the applicant was never in breach of the agreement. But again, that's one approach. The other approach that Stan is advocating is perfectly valid, and the board is well within its rights to look for that kind of language.
Well, as I sit here right now, and I'm willing to be convinced otherwise, I would leave 7C the way it is, but I would agree with Stan on 8C to remove the modification by the Board of Selectmen, but that's.
So Stan, is your concern that a future board is going to be, I guess, more lenient, or what is your concern with these two?
Well, I think certainly with the applicant, we have not gotten a lot of detail as to what the plans are beyond the retail establishment. That's number one. Number two, they have come to us and said they want to do what they want to do. And I think, they need to be aggressive in getting it done. I also, to your comment, there could be a different board. I think if town council could put something in there that says, we can revisit this agreement, but I think we should make it not as easy as just issuing a waiver letter. I think if we're going to do something that deviates from this host community agreement, that there needs to be a bit more deliberation. And I'm willing to get a suggestion from town council that there's some, paragraph at the end that says if any of these sections need to be redone, then we have a discussion and modify the agreement. But I would like it stronger than just a letter of a waiver letter. That's sort of my intent here.
Yeah, so maybe it could be that it comes back before the board at a meeting rather than.
Right, and we have to make a
public
modification to
comment.
this agreement, because there could be, there could be, we could have a balloon here, a water-filled balloon where we squeeze one piece and some part of the balloon comes out. It may be more complicated than just a waiver letter. So, you know, I think this is we need to make sure that we follow this and it's looked at strenuously and completely. So,
Is there some procedure you want to put in place before having a waiver, like demanding a hearing or something like that?
Yeah,
oh,
I mean,
I
I
would
think,
think so. I would think so. I think we should have, if this agreement has to change into something of substance, then yes, I think we should have a meeting with the selectmen, perhaps a hearing, and I think the agreement needs to be modified. I'm not inclined with something of this seriousness to just say, okay, well, we'll have a meeting and we'll do a waiver letter and sign it off and it'll be done. I think it needs to make sure that we have community participation here.
But I don't want to open the door to renegotiating the whole agreement
No,
just over
obviously,
one section.
no, obviously, it would have to be crafted so that whatever language is in here is, we're limiting the renegotiation to something very specific. Whether it's we have to extend the 3-year window, whether we have to do something else, but no, it's not opening up the entire agreement, but it's to deal with a certain specific section that the applicant is asking for some relief on.
Okay.
I'm fine with the waiver concept. I agree that we should have, the applicant should come before the board and there should be a hearing. So we have public input.
Yeah, I'm fine with putting a procedure in place before awarding the waiver. So
Brian, do you have thoughts on wording for that we can kind of pull together and try to work out?
I can certainly do it. I'm usually reluctant to draft on the spot.
Oh, no, I don't mean now. I mean,
Absolutely.
Yeah.
I often have to draft from the spot. I just choose not to if I can avoid it. I try to do that here. We can certainly.
it wouldn't be in our, it would not be in our best interest to sit here and negotiate amongst ourselves. But I think if you have enough structure or enough insight from the selectmen, I think you get to where they're trying to get to, and I think you and I can craft something.
I'm already there. I hear what you're saying in terms of what you're looking for, and we can certainly, in where we've got waivers that the board issues, we can include a level of process so that the public knows what's going on. There's a hearing and the board will have some level of deliberation and the applicant has to make a case. We can certainly include that type of language in the agreement.
okay. So I'm okay with doing that for 8C and 7C. And Stan, what was your next paragraph?
Hold on. Right to 8C. Let me go down again. 14B. The agreement should remain in effect, but operations should cease when the final community impact fee is due but not remitted to the town. So if we're not getting paid, then the agreement should remain in effect, but they need to cease operations.
We have that addressed in a different section.
Okay.
This section deals with when do we know we need to renegotiate and how long is the agreement? I'll pull it up. Just flipping pages towards the beginning. This is section 6, payments and compliance with the agreement as a condition of operation, default and remedy. And this essentially says, if we're not getting paid, we can seek to shut them down.
Okay, that's fine, as long as that's fine. Then also in that same section, C, it was just a blanket statement that said, upon the 4th anniversary of the opening date, the party shall negotiate in good faith a new host community agreement to succeed this agreement. But I think we need to put some additional language in that we are requiring them to be fully built out with their retail product manufacturing and cultivation within 3 years. And if that doesn't happen, then 14C can't commence.
Well, let me ask the question of what remedy do we have if they're not built out after 3 years?
Well, right now, the way it's drafted, if they're not built out within 3 years, they're in default, and they wouldn't be able to proceed with another piece that's not in place after 3 years. They're stuck with what they've gotten at 3 years without an amendment to the agreement. That's the way it's set up right now. They've got 3 years to be what they're going to be, essentially.
So whatever they are at the end of 3 years, that's what they're going to be for years 4 and 5.
That's the intention. Yes, they've got 3
Okay.
years to do it.
So what's wrong with that, Stan?
Well, if they've come in to do what they say they're going to do and they haven't done it in 3 years, we shouldn't start negotiating a successor HCA agreement in year 4.
Well, when should we do that then?
We shouldn't do it at all.
Okay, so what I understand is I understand it.
Because
The problem with that is that after year 5, they don't need an HCA to continue operating. And without an HCA, we don't get any remuneration. So you're taking away any motivation from them to renegotiate or a new HCA. They don't have to have one to operate.
Well,
all right, well, let me ask town council.
Yeah.
My concern is that, let's say we get through all this process, they get their retail operation, and they do nothing else. My intent and goal would be after year 5, if they have not done what they say they were going to do from the start, that they need to cease operations entirely. They just cannot continue to perpetually have just a retail operation.
okay.
Okay, so if they don't get it all done, they're gone. That's what I want to see. So how do we do that?
Is your concern, Stan, about revenues? Like you want
No. Revenue is secondary. I think the applicant has specified that they want to do a number of things at that facility. Now, if they only do retail and we don't allow them to sublet, it makes it very difficult for them to continue anyway. But the goal is they either do the whole thing or they are gone in 5 years. Because I don't think anybody wants a perpetual retail operation at that location. And yes, revenue is part of it, but either they do what they say they were going to do, or they're gone. That's the way I look at it.
What are the legal options there?
I mean, we can draft, if that's the intent of the board, we can draft it that way. I have to think about it a little bit. But I'd also put out there, it's raised, well, if they're only retail and they don't do the other components, we want them gone. I mean, on the flip, what we wanted on the flip side, if they only set up a cultivation and product manufacturing facility and never commence the retail within the first 3 years, would it be the same issue? We want them shut down if they don't have the retail component at that point in time.
Well, I think that
I'm not comfortable with where you're going with this, Stan. Certainly, I just don't know how you can make it stick. I don't know how you can tell someone they've got to shut down in 5 years. And so
well, but they're coming to us with a proposal to do a number of things.
yes.
The easiest of all of them is a retail operation, which I think which is what the residents have the most trouble with. And if part of this is, yes, that there is a revenue component to this. But if they only achieve the retail operation and never complete the rest of what they were intending to do, to me, that's somewhat bad faith.
I think I think we're kind of, if we did this, we'd be painting them into a corner.
No, why would be, they have said what they want to do. I
But
mean,
they've
we're
been
not,
clear that their primary goal is the retail. And they've been clear that they really don't have the expertise to do anything beyond that. That they've said, if my recollection is, they've said, they've put that other language in there just in case. And so they've never said that their business model depends upon doing that. As a matter of fact, they've said the opposite. And I'm, you know, I guess I feel like it would be a better thing if they expanded the scope of what they're doing and de-emphasized the retail portion of it. So I don't want to penalize them for trying to do that. But to tie, yeah, you know, the whole board of selectmen could turn over in 5 years. And I don't think we should be making that kind of determination of what the whole community should, what's good for the whole community 5 years from now. I guess I'd put it that way. That there's got to be an opportunity to renegotiate a new host community agreement for the benefit of the town. And if that host community agreement may demand that they start some other processing or growing facilities in 18 months. I don't care. But I don't think we should be, since it's possible none of us will be part of the board, I don't think we should not give the town any options 5 years from now.
But the agreement we're negotiating now states exactly what the applicant wants to do, and provides for a timeline of when the applicant wants to get it done.
Okay.
I mean, we're not demanding them to do anything. That's what they have. That's what they want to do.
Right.
Whether they have the expertise or not, that's what they want to do.
Okay.
That's what the agreement has to say. So
Okay. And there's 5 years of changing business circumstances between now and then. Things that are totally out of their control could affect their ability to implement those other changes.
But that's not, quite frankly, that's not our concern in this agreement.
Well, you know, what you are making your concern is you're going to determine, you're going to take out of the hands of the town 5 years from now their options. You're going to prohibit the town from engaging with this group of people 5 years from now.
No, what I'm asking is, do you want the town to continue if the applicant doesn't deliver on what they say they were going to do? And I understand that there are going to be circumstances, and we've asked the town council to put something in there that this agreement can be renegotiated, or certain aspects of it can be modified.
But your proposal would completely take out of the hands of the town and the Board of Selectmen who are in place at that time any opportunity to renegotiate a new host community agreement if they don't meet their.
No, I'm not saying that. I'm not saying. What I'm saying is that 14C just says you're going to start doing it regardless. I think there should be some conditions upon that of when that renegotiation for a successor agreement is done, not just that it automatically starts. I'm not saying take away any options. I'm not saying denying the town anything.
Well,
But
You're
14
but
C
what
says
you said
we're
was-
just gonna
what
we're
you-
just gonna start renegotiating regardless. I
what you
think there's
did
gotta be-
say is if the build out's not complete, then there should be no negotiation. That's what you said.
Yes, that's what I said, but I'm willing to modify that.
Oh, okay, that's different. That's a
Okay,
different
I-
discussion then.
I'm willing to modify that there should be some conditions, not that it automatically starts.
Okay, what conditions?
Town council, you want to chime in here?
So you're looking for conditions as to whether we're gonna renegotiate the host community agreement at a certain point in the future. In terms of whether we negotiate a new one with them or not.
Right,
Is-
because in the agreement, there are certain stipulations. Within 3 years, they're gonna do this.
Yeah.
So if they don't get it done within 3 years, what's the ramifications of that? Because
Well,
if that doesn't mean anything, then why put it in there?
Well, the way it's drafted now, this is section 7, says they've got 3 years to build out, to be what they're gonna be. And they can't add new components to their intended facility if they're not in place after 3 years. So they've got 3 years to build out. At the end of the 3 years, they are what they are. And unless there's a waiver, as we put in place, and we're
Right.
gonna have a different language there. So if all they ever open is a retail facility, that's all they may be, if that's all they have open at the end of 3 years, unless the selectmen waiver extended. On the flip side, if all they open is a cultivation facility and never get the retail off the ground after 3 years, same thing, they're stuck as what they are at 3 years. And then under 14, if we get to the 4th year and we want to renegotiate, I mean, the successor agreement could have different language on those points. There's nothing stopping the board at that time from negotiating something different, saying, we want you to stay as you are, we don't want any more of these other uses, or we wish you had developed the cultivation facility and you didn't. And so we want, if you want to renegotiate with us, we need a process in place for that to happen and a timeline for that to happen. Those are all possibilities. The new agreement for the facility that starts getting negotiated in year 4 is open to the parties in terms of what they're interested in doing at that time. And another goal of the starting the renegotiation process in year 4 is, again, the statute currently requires that they have a host community agreement if they want to operate in town. I don't know if that's going to change. The statute also says there may be a community impact fee, but it can't go for more than 5 years. If the town wants to have that community impact fee after the 5th year, I think you'd have to renegotiate a new agreement, which is one of the reasons we have this here. But another reason is, if they're in breach, if they don't negotiate with us in that 5th year of operation, when they pass the 4th year and now it's time to renegotiate, if they think they're going to be able to not have a host agreement in place and operate anyway, they'll be in breach of this agreement. We can take action to shut them down. So they have to come to the table with us in that final year so we can put it all together and see what are the terms and conditions going to be for continued operation in the town for however long the new agreement would call for. So if we want to interweave the scope of the facility in section 7 with whether or not we negotiate and whether or not they can continue to operate, we can do that if the board's inclined. I just think it's a little trickier than just making some changes right now. But if you want Don and I to look at that and work with the applicant on that, we can certainly do it.
Mr. Chairman, Mr. Cat has his hand up.
Okay, Mr. Cat?
Thank you for recognizing me. I just wanted to chime in that, and I was going to wait till the end, but I just wanted to say one thing while it's still fresh. We have always anticipated going through the spectrum of full development, and the only reason that we haven't proposed concurrent development from the beginning, as we were trying to make it a self-sustaining business from moment one. The more we've researched the fit out for the back building, the more we're realizing that it should be fairly easy to convert it to full use for both cultivation and manufacturing. And since our last meeting all together, we've had some folks on site to confirm that what Covum is leaving behind is substantial and already in place. And with that said, we do want to go full force with the project, not just the store. And you know, we realize that we've proposed certain things and we're all looking forward to doing them, but there are certain things beyond our control that we need to remember, like federal government, state. And I do appreciate whoever said we should maybe you might want to consider the fact that there are factors that are beyond my control and the control of anyone at the town level when it comes to state licensing. So any time would be appreciated in that regard, because we have no control over that. I can tell you right now that the board's about to be in flux and they might not have enough people to have a quorum for the next couple of months. So that's not anything that we can handle ourselves, or we should be punished for, I don't think. But I just want to mention that there are other things beyond our control. In regards to all the points that were made, if I can just go through them. Stan mentioned the limited extension deadline, limiting the extension deadline. 3 years or nothing sounds good to me in terms of trying to get that project done. I don't see why we wouldn't have all facets of the property firing off in 3 years. The only thing I was going to say is it might be nice if that 3 years was from the date of provisional licensure from the state of Massachusetts. There is some time between now and then, but that would help us. At least it would set the date further forward. You could also set the date from the opening of the store or anything else that is a larger landmark where we actually begin the process of the work at hand, because there is a lot of dead time that's created in these situations, and they may be beyond our control.
All right, Mr. Cat, Mr.
Yep.
Cat, I don't want to start negotiating.
Oh, no
online.
negotiation. Just want to
Well,
mention.
I appreciate your viewpoints. You're bringing up some good
Thank you
stuff,
for hearing me out.
but I think it's better suited to address those questions with town council.
Totally
and
understood.
town
I just
administrator.
want to jump in on that one point. We do want to proceed as fast as possible, and we have someone that we're looking to partner with who is coming aboard on our team to be the grow expert for us. So we don't want to just to change the flavor of the conversation. Just to let you all know, it's not like we're trying to slow this down. The phased rollout might be more concurrent than we previously imagined. So I just want to let you know that before we continue talking. Thanks.
All right, thank you. All right, so can we leave it that Don and Brian Falk will try to find some, put some qualifiers around the renegotiation step?
I think that's fine. I think that's fine.
Okay.
I
And
mean,
what's
none
your
of us
next
are
point,
lawyers.
Stan? Because I do want to, I know we're running really long, but I want to
Yeah.
get to the other people who want to speak too. What was your
Yep,
next point?
yep. No, I think that was primarily it.
Okay.
The last one was 15 with
Oh, the 15 days. Yeah, I think we need.
Yeah,
If
I
they
think
want to assign this to some other entity, we need more than 15 days.
yeah, I think we need 30 days or something like that.
At least
That's
30.
a fair point. Yep.
Yeah.
Okay.
Yep.
All right.
I would say 30 to 60.
At this point, I'd like to open it up to public comment. Again, if you use the raise your hand feature on Zoom, that's the best way to go. Otherwise, if you're going to do it through the chat, please make sure you're identified. And if your name is not posted on the Zoom when you do speak, please identify yourself. Are there any hands up? I don't see any hands up. Does anybody have any comments or questions?
There is one.
Mr. Lawless, you have the floor.
Thank you. Tim Lawless, Bolton Woods Way. I had a quick question regarding if they didn't develop anything other than retail after the first 3 years. Just curious what those buildings would become if that's in the agreement that they can't be subletted, or no?
Empty.
Empty. So they buy them.
I mean, that's, that would be my expectation.
Okay.
Anybody else feel differently or?
Nope.
Okay.
All right. Thank you.
Pat Clark, you have the floor.
Hello, Pat Clark. Thanks. I have a question. So if hypothetically here, so if the board decides to pass on the agreement, I don't even know the term, so help me out here, right? Like, let's say the board says, nope, we're not doing this. I'm under the impression that Mr. Cat can still pursue it, right? Yeah, I was hoping you could help paint that picture a little better for me, if that, as a hypothetical.
Okay, so the board has the option of deciding not to decide tonight, or making a decision, or sending it back. Well, it sounds like we're already sending it back for more discussion. But in the event that we can never find an agreement on this, that I want to turn over to Mr. Falk. Brian, can you address what happens if the selectmen vote do not vote or vote against this agreement?
What I'll say is that this facility, like any marijuana establishment, has to have a host community agreement in order to proceed. If they don't have a host agreement, they can't get to start, because they can't apply for a CCC license. So that would be the impact.
Okay. Mr. Clark, that's your question?
Yeah, I appreciate it.
Okay.
I just thought from another meeting that there was still like another avenue that Mr. Cat could go, even if the town or the selectmen turned it down.
You might have gotten that impression from me, because I did say something like that a month or so ago, but I'm learning.
Me too.
So, all right, thank you. David Bergsbagen. Please unmute yourself.
Hi,
Hi.
thank you. I have a number of questions, but I'll try to keep this limited. I wanted to make one comment, though, about this process. It's my understanding that Mr. Lowe and Lovecraft have been in negotiations for making my best guess, but maybe 8 to 12 weeks. I don't know if that might be accurate to state, but something on that order. And we've just recently gotten this draft HCA, I'm going to say about 2 weeks ago. I'm not a lawyer. I appreciate Mr. Falk, can read through this document, and all the selectmen are somewhat familiar, I'm sure, at reading a document like this. I guess what I just want to make a point of, I feel very uncomfortable with having any kind of vote taking place, and it sounds like one wouldn't be happening tonight, but even within like 2 weeks, that's just a very short period of time to be, taking a vote on language that is fairly new, to the town and a lot of the people on folks on Bolton Woods Way. So I just want to make that comment. To me, this is just way too early in the process to be having any kind of vote. We need to digest this more. I also wanted to make a comment regarding the odor mitigation section in the HCA. I'm very familiar with cultivation in California and the odor that cultivators do emit. It's horrendous. It's amazing when you drive by those facilities in California. And I'm very nervous about cultivation in the town of Bolton at a facility like this. And I saw that there is a mitigation section And the way it's designed relative to town bylaws, which there's a town bylaw that speaks to odor mitigation, or at least odor as it relates to someone being able to smell. But I think that the way it's stated in the town bylaw, it's at the border of the facility. It doesn't say anything about odor up the road along Bolton Woods Way. So we may be able to smell it, I believe the way it's stated, up Bolton Woods Way, but maybe not right at the facility. And I say that because they may put in, noisy fans to blow the odor contaminants out away from the facility so you don't smell it on site or right at the boundary of the site, but you would smell it potentially up Bolton Woods Way. And I would be very nervous about the language, the way I understand it, that is mentioned. The other thing too is there's nothing about like noise mitigation of such fans. They could be aircraft, type jet engine noise levels. There may be some language in the town bylaws about that, but I just wanted to make sure that was at least clear and understood.
Well, actually, a lot of what you're discussing will actually take place during the special permitting process.
I understand.
So the HCA is not the all-encompassing document to address all of that. That will be done as part of the special permitting process, planning board involvement and the like. So a lot of that will be addressed at that point in time. The HCA is not designed to finalize and address all of that in that particular document. I mean, as far as the vote, this is going to go back and be reworked between our town council, Don Lowe, and have further negotiations. So I think it's probably going to be a little bit of a while before anything comes back to us for a vote. We're all going to do our due diligence on this.
Yeah, David, I'm reading the section on odor control, and what I read is complaints received by the town concerning odors that are detectable off the facility site. That specifically addresses, to me, what that says is things outside the property line.
Does that specifically say that, or is that, how is that actually
Provided to
defined?
the company concerning, or I'm reading it, concerning odors that are detectable off of the facility site shall be addressed thoroughly and expediently by the company.
So if I smell that a mile away, then that would mean that would be an issue, and
Yeah.
They would have to mitigate that.
That's the way I read it, yes.
And it wouldn't be restricted to the town of Bolton town line. So if I smell that,
I'm not negotiating on behalf of Stowe.
well, I'm asking. It's just right at the Stowe line. So that to me it's relevant.
Complaints about smell off-site need to be addressed by the company. It doesn't say what direction or how far away. Let me get back. Bridget, I believe you have, your hand is up.
Yes, hi, actually it's Greg Matty with
Oh, hi.
Bridget, Bolton Woods Way. And I had a question about section 8F3. It's the operating hours. And specifically, it states that the retail portion of the facility shall be closed 30 minutes before and 30 minutes after pickup and drop off. And my question probably is for town council. And it's what I'm not particularly comfortable with is it saying that this restriction can be modified or waived by the Board of Selectmen. And I think, Bob, you made the comment earlier that the board could change in 5 years or however many years down the road. And could this be something that or any of the things where it says the Board of Selectmen can just change it. You know, if the neighborhood doesn't want it, could we just make it so that that's not modifiable? Because that's a very reasonable request for a bus stop.
As I mentioned before, this is an approach that gives the applicant and the board flexibility, but it's not the only approach, and it's not one the board has to adopt. We don't have to have that provision there, and the board is free to not grant a waiver if it doesn't want to, if we left the language alone.
Right, but again, all the powers with the board. So if everyone on Bolton Woods Way agrees that it should be closed 30 minutes before and after as currently written, but 3 people on the board say, I don't think it really matters, then the neighborhood is impacted, and I think that should be addressed.
Well, let me add that this also empowers the Board of Selectmen to make that more restrictive.
So, Bob, you cut out. Could you
Okay.
repeat that, please?
Yeah, the way this is written, it also allows the Board of Selectmen to make that more restrictive.
Right.
So maybe a minimum of that could be the language. It really is disturbing to have the bus stop and this development so close.
Well,
It seems like a real disconnect from a proper town setup.
Well, I think as we discussed earlier with some of the other things where the language was a waiver by the Board of Selectmen, I think at the very least, there needs to be a public hearing and citizen input, on these things. So I don't think that there's going to be a situation where, well, I can't say that for sure, where a change in the Board of Selectmen might do something different, but it'd be highly unlikely that they would make it less restrictive, as opposed to what the Chairman Sikansky would say, maybe making it more restrictive.
But I'm fine with taking whatever we do with 8C and 7C
Yeah,
and applying it here too.
Yeah.
You know, I'd like to see what that solution is before I commit to it, but I'm willing to give that a whirl.
All right. Thanks for considering that, guys.
Sure.
Sure.
Avaradi, did I say that correctly?
Yeah, Bob, this is Lou Veradia. I'm on Bolton Woods Way as well. The number one thing I was going to raise has already been raised, which is the smell. I'm coming to find out that this really is a huge problem with these type of facilities. So we've talked about that enough, and I hope it will get addressed, because I have a strong feeling that this issue is going to become an issue once they start growing. And then the other thing is, if they're going to have this large facility of growing, that raises the question of our water tables. So our wells are pretty low up in our area. Everybody kind of already knows that. So now we're going to put a large facility to grow plants, which is going to utilize our resources for water. So what do we do at that point? When they go in there, they start growing, and all our water starts going away. What actions or what protection do we have on something like that? What's going to have to happen is that we're going to have to spend a lot of money to re-drill and go down another 200 feet. So those costs are going to be painful. So how do we address this concern that we have?
I'm going to start by confessing my ignorance, or showing it by the next question, but do you have a community well, or does every house have its own well?
We each have our own well, yeah.
Okay.
Yeah, I just replaced my well, so. And
I know it's a painful experience.
That's how I found out how low my water level is.
Right. I don't have an answer to that right now. You know, it's certainly something that could be addressed in the next community host agreement, but I don't know what the effect is going to be. I understand that growing marijuana requires a lot of water, but I don't know where the water table is or any of the geology of that area. I
So
don't know if the other selectmen have
can they
specific.
truck in
opinions
their
about
own water then? Can they bring it in without using our water? Can we have something in the language where they are responsible for their own water resource versus using our wells?
It's an interesting idea. How do the other selectmen feel about that?
I mean, I think recycling water runoff would be something to look into. Brian, this would be like a community impact in terms of water. Have you heard this before?
I mean, it's for the most part where I've worked on these, there's been public water, and as long as there's sufficient capacity, it hasn't been an issue. But that said, I mean, this is not an issue that was on our radar screen. And if it's something that the board wants the town administrator and myself to think about and further negotiate with the applicant, we can do it. It wasn't on our radar screen. I wasn't aware that it was an issue in the area, and you know, I appreciate the public bringing it up. It's certainly something we can look into if the board's so inclined.
Stan, Jonathan?
I think it's probably something we need to look at. I don't think any study has been done in terms of the wells up at Bolton Woods Way and what the well is at the current facility that's been shuttered. So I think we need to at least look into that.
Okay, we're going to have to do some work on that then. Yes. All right. Thank you, Mr. Avardi.
Thank you.
Tim Wallace, please.
Hi, yep, this is Krista Lawless. I just had a couple questions and comments. I appreciate everyone's time tonight. Obviously, so I am also a Bolton Woods Way resident. Clearly, this is impacting our community the most, and you know, some major concerns have been raised about traffic, the bus stop, you know, possible gating of our community. So, you know, hypothetically, if all of this were to go through and this, you guys, you know, the board agreed to move forward in this process, I'm just wondering, you know, what sort of things would benefit our community if this is something that, you know, we don't have much of a choice on moving forward. How can the company and the board kind of work with our community, and what sort of benefits would we see from this since we're going to be impacted the most?
I guess I have to say that we are negotiating on behalf of all the citizens of Bolton. We're spending a lot of time on the concerns of the people on Bolton Woods Way because you are the most significantly affected by it. The town has voted to accept marijuana businesses in town, that this is the appropriate location. And we're doing everything we can to mitigate the conditions to that neighborhood.
And I appreciate that. And like I said, you know, you guys have to do what's best for the town. But in all honesty, I know that if I wasn't a resident of this, I probably, you know, as you can see, probably the majority of the people on this call right now are Bolton Woods Way residents, with all of our concerns, one being, you know, traffic and also our home values. I'm a fairly new resident. We moved in earlier this year. So, you know, that's a huge concern, is what is this going to do to our home values? Having this type of facility so close to a neighborhood, as well as, you know, as Mr. Cat had said, his intention is to create this cultivation, this grow facility. And I think some major concerns were raised about the water tables, the smell, the odor, and also, you know, the impact to the environment. I don't know where all the wastewater is going. We are backed up to conservation lands, so I don't know what impact that would have on the environment as well. I know the trails are used heavily used by Bolton Woods Way residents as well as people from other towns. So the impact on the environment itself as well.
Okay. Thank you. David Bergsbakken.
I wanted to also double that mention on the housing values. That's a primary concern to everyone on Bolton Woods Way. I was going to say the exact same thing. I also wanted to make mention of the conservation land and Annie Moore Trail, which it abuts that facility. I'm not sure if that makes any mention in this HCA at all, and maybe that would come up at the special permit process, but seemed kind of, it seems, since it's a trail that the community would be able to have access to, that it should have some kind of mention in this document. The other thing I wanted to mention too was the impact fee. The language is kind of vague as to what that's really covering. If I've read the Mass Cannabis Control Commission's guidelines, that's supposed to be auditable, that impact fee. So if Don or Brian Falk could speak to the exact, what is actually that covering, and how do you know how much is going to be required? Or is it just you're picking a number out of a hat and taking the maximum possible value?
I can address that there is a requirement that the town keep track of its costs with respect to the facility, and upon request by the Cannabis Control Commission, provide them. They're public records anyway. The impact fee, though, is always negotiated between the parties, and as you pointed out, the maximum by statute is 3% of gross revenues, and that's what this agreement calls for. And we have provisions where the parties both agree that coming up with what the actual impacts are can be difficult to do in this situation. And so we agree that this is the number we're not gonna argue over. It's this number.
But if I'm not mistaken, that's a number that's supposed to be auditable by the state. So if you're kind of picking that number, it just sounds like it's kind of being picked out of a hat, and you're picking the biggest number. So to me, you should be able to provide a specific dollar amount that's going to be required to cover the costs of the town, due to this impact fee. What is that number, I guess, is what I'm asking.
Well, Mr. Falk pointed out that we have to be prepared for an audit by the Cannabis Commission if required.
And I'm asking how much is expected? What is the dollar amount?
If I ever knew that, it escapes me at the moment. I don't know that we discussed a specific dollar amount because it's a percentage of sales.
And that to me seems like a
Specifically why
question.
you would not get into a dollar amount. The maximum impact fee allowed is 3% of gross sales, and 3% of gross sales will more than cover any impact that we've had.
Right, that's the maximum.
It seems to me like you could come up with a dollar amount. I'm not asking that it be in the HCA, but the town should be in a position to know what the expected costs would be on the town side to cover these expenses.
And what I'm saying is, rather than hardwiring a dollar amount into the HCA, it is more beneficial to the town to have the maximum percentage of gross sales allowed under the law.
Yeah, I'm not asking that dollar amount be in the HCA. I'm just asking the town in this meeting, what is the expected dollar amount?
Of how much we expect to collect?
No, of the expenses. What are the expenses that you're expecting to be covered? Police details? road maintenance? What is it that's expected to be covered here? And why are you choosing this number?
Because that's
I'm
what
just-
the state, that's the maximum that the state allows. 3% of gross revenue from the operation. That's the maximum number we can levy. That's it.
Yeah, I understand. I understand that you're picking the maximum.
David, how does this affect your opinion on whether or not we should accept the host community agreement?
It seems to me that if this town is picking this number, and it's by the Massachusetts Cannabis Control Commission's own guidelines, they're saying that this is an audible amount that we need to be accounting for, that the town should be in a position to say, yes, we're getting this 3% of gross annual sales, but we expect, I don't know, $500,000 to be, delegated to police details. I don't know what that would be.
But providing that information is not part of the negotiation.
Right.
It's not a required part of the negotiation. Lovecraft has agreed they don't need to see specifics to justify the 3%. The town does have to be prepared for an audit.
By the state.
By the state. Right.
I'm just asking what is that number? That's all I'm asking. It's based on their sales, but what if they make $100,000 a year? I don't know. So
one of the reasons that
traffic won't be a problem then.
I understand.
That's true.
Mr. Chair, if I could add, one of the reasons that most host community agreements are set up this way is because this industry is still brand new and the impacts are difficult to estimate now and versus when the facility might open. Other things that might impact the issues the town faces and what other facilities are open nearby, either in Bolton or outside of Bolton. If you may recall, 2 years ago on Black Friday, when the only retail operation opened in Leicester, first of all, a lot of people learned that there's a Leicester, Massachusetts, and people saw lines, miles long. Those are all gone now, but there were significant impacts at one time, and those impacts are not there now. So what the town's actual impacts may be, as we state in the agreement, are difficult to estimate now and maybe in the future, but the parties stipulate that 3% is a fair estimate of those impacts, and that's why the agreement uses that figure.
Mr. Chairman, I would say I think we've heard a lot of discussion from the citizens. The HCA still needs some work. Can we close this portion of the discussion?
We have one more hand up, Mr. Varadi, and that will be the last comment.
Thanks, Bob. I'll be real quick. So
I'm sorry, Mr. Varadi. Can I just like to let the chairman know that Mr. Crump has had his hand up, but he's having trouble finding the raise hand feature.
Yeah, I'll relinquish my time.
Okay, I'm sorry, Jenny, who was that?
Neil Crump.
Mr. Crump? Go ahead, speak, please.
Thank you. I think my hand
Mr. Varadi.
I think my hand pops up and then it goes away after 5 seconds. So, thank you for letting me talk. I think, I'm hoping by now that the board is pretty clear that a vote for this would ruin our neighborhood. So I hope that's kind of clear, and that you're also considering the emotional impact that would really do to, over 100 people, families. I moved to Bolton a year ago. Part of the reason I moved here was to have, and, to be in a town that really cherished its history, to be outside its, respective space in the community. And I'm going to tell you, if I would have known that this was going to happen, I would have never moved out here. I would have never bought a house. And so, by the way, I do come from Denver, where, they are many, many years ahead of, Massachusetts when it comes to allowing groweries and retail. And one of when I know it's been brought up a couple times already about the smell, but there are ongoing lawsuits around the smell in towns, and they're about neighbors commenting that they can't even go outside. There's been also comments in air, that there's about smell within there. And so one, I think the cultivation from Bolton Woods Way would completely ruin the neighborhood. And on top of that, I really don't understand how this establishment would fit with, know that your vote on any way of this would really be devastating our neighborhood. The second thing of this is that if you even voted a vote to be able to do this at the cost of our neighborhood, I would think and really hope that some provision would be in there that any impact into Bolton Woods Way would have to be fixed by this company, or that they'd have to leave. So I love that the smell thing is in there. I'm going to probably guarantee you, I'd bet money on it, that we're going to smell it. But I would also love some sort of stipulation in there that said if property value goes down, they either have to fix that, they either have to leave, or they have to adjust the cost if the desirability of the neighborhood goes down. I mean, I know we're a small neighborhood, but we bring in over like $300,000 worth of tax revenue into the town. So I definitely think that this is very important. And I think that if Bolton Woods Way has to take the major brunt of something, then that we should be protected. And I see very little in this about protecting Bolton Wood Way. And so I think adding some provision in there about water impact, about property value impact, about smell impact, about desirability impact, because I'm going to tell you, I would have never bought this house. And, and if this does go through, I will be selling my house because of this. So I want you to kind of put a face, and I hope you can hear the emotion on the impact that this would really do. I know it's been mentioned in other kind of meetings that the board thought that they couldn't deny this. It sounds like you've noticed that you can. I've done research that Concord has recently denied and not done a community host agreement. And one of the main reasons that they did this is that one of the medical doctors, a respiratory therapist and doctor, came in front of the Concord board and testified the impact of the harm the smoke does to the community. And what it does for residents to breathe in that air. And Concord voted it down because of this. So, that we're not talking about putting in, for instance, the microwave factory that's down there. We're really talking about multiple problems that I just don't understand how this fits with Bolton. And the last comment, and then I'll let you talk, is 7C, I think, is so vague. I think that it really lacks detail. I think it allows carte blanche for Lovecraft and Associates to kind of do whatever they want in that property. And I have to say that this is probably one of the poorest designed plans I've seen. Like I have seen, like if last time we were here and we saw, the apartment complex it was detailed. It had photos. It was laid out. They talked about water tables. They had plans. Yeah, I mean, much more impressive in their ability to actually understand the community and to be able to present it in a really professional way. So I'll let you comment.
Thank you, Mr. Crum. Back to the selectmen. Is it fair to say that at this point we want to give it back to the town council and the town administrator for further work?
Yes.
Do we need a motion on that, Mr. Town Administrator?
Just to have it on the record, I would say yes, please.
All right, could I have a motion, please?
Make a motion that we ask town council and the town administrator to go back and do further refinement of the host community agreement and negotiation with Lovecraft.
Jonathan, you got to unmic yourself.
Second.
All right, all those in favor, please say aye.
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 All right, thank you. We'll get Brian and I will get a meeting scheduled
Jenny, you gotta unmute yourself, Jenny.
I think Jenny is trying to remind you that you need to do a roll call though, because we're.
You.
Yeah,
I don't know why you couldn't hear me because I was unmuted. That was strange. Roll call, Wysocki. Can you hear me now?
Aye.
Keep
Aye.
Kansky.
Aye. All right, thank you, everybody.
Thank you.
Next on our agenda.
Thank you.
Next on our agenda is to consider a request for a little free library at 716, 718 Main Street. Emily Winter. Are you?
Hi.
Hello.
So Sarah is also here, and she actually has a little more information about the library. I just own the property that we're proposing to put it on.
Okay.
Hi there, I'm Sarah. Thanks for this time tonight. I, on behalf of the Neshoba Area Social Justice Alliance, am proposing a book sharing box known as a Little Free Library. It's a small public box where citizens can freely share books. The boxes, which represent the global community, can be found in all 50 states and abroad. Many of Bolton's surrounding towns, including Stowe and Hudson, have little free libraries. And so in partnership with the Winter family and Silver Unicorn Bookstore in Acton, we're hoping to erect a custom-built little free library on the Winter's property at 716-718 Main Street. The Winter family has granted us permission to have the library stand on their private property on the small lawn area outside of their future general store. And Emily can speak in detail to exactly where we're proposing it could go. It will be set back from the Main Street sidewalk and ADA accessible. I have pictures to share of what it will look like, but it definitely fits with Bolton's historical and rural aesthetic.
If you could answer something that's just noodling around in my head, I generally think this is a good idea. But given the way everything is being quarantined and other safety measures that we're going through, how does this concept deal with that, given the present conditions?
I want to make sure I understand your question. We're proposing it be built at some point this winter, assuming that the ground is not too hard. Otherwise, it will be erected in the spring. And because it's outside, anyone walking down Main Street, either to the library or to school, can leave a book or take a book. And the other little free libraries like in Maynard and in Hudson and Acton offer hand sanitizing to open and close the library.
Are those libraries remaining open during this time?
Yep, it's just like a freestanding mailbox and they're open and accessible to all.
I think what the chairman is asking is, and I think it's a great idea, because there is one in Hudson right off of 85. But the library, our Bolton library, is quarantining any material that they get from an outside library through CMARS for 7 days before they actually put it on the carts to give to the residents. So you have material coming in and out, regardless of the hand sanitizer that you're proposing. The actual physical library material. I guess the question that the chairman's asking is how is that being dealt with, given the current situation where our library has to quarantine the material that they get from another library for 7 days before they even provide it to a resident. That's the question.
Okay. I understand now. I think it's something for Emily and I to discuss further. We wouldn't have the capacity to quarantine books.
But I think the idea is great.
Yeah,
I love it. Yeah, I think
I like the idea too, but I just gotta, as
Yeah.
a public official here, I've got to ask these kinds of questions.
Absolutely. No, I
I
agree.
mean,
I agree with
if you tell me that this isn't going to go into operation until everyone's vaccinated sometime in summer, I'm fine. But you wouldn't be here now if that was your plan. So I'm
And
just,
well, no
just
one's gonna be, we're not all gonna be vaccinated by the summer. Let's not even think about that.
all right.
Does it change things that it's not going to be on town land?
Well, it has nothing to do with town land, has nothing to do with town land. It is purely a public health issue.
Yes.
That's all it is.
I mean,
Okay.
you could look at this as you're asking us for permission to enable a communicable disease to be transferred more easily. I mean, that's a very cynical, negative way to do it. I'm sorry to bring up that aspect of it, but I do have to be concerned about that.
Well,
Yeah, no, I appreciate your concern. I don't know of what sort of data is out, scientific data is out there in terms of rate of transmission through books, but it's definitely worth my researching.
Yeah. How I would suggest that I think the concept is great. And I would say I haven't seen a picture of what the actual structure looks like, but I think that would be helpful as well. But perhaps we can conditionally approve this conceptually and whatever they need to do to get the structure actually constructed, but not necessarily put into the ground. And let's let them proceed to a point, and let's see what happens in sort of the spring timeframe, and then make a determination as to whether it's safe to actually open it up for business. But
Yeah, or you can build it, but you can't make it operational without coming back to the board.
yeah, I think that would be, I think let these folks move ahead, because I think it's at some point where we're going to get there. I'm not sure exactly when we're going to get there, but
Yeah, I'm not at all inclined to say no at any point to this, but I just have to be dealing with the public safety aspect of it also. And it's very sad that we have to worry about the public safety aspect of people borrowing books, but
Mr. Chairman, I'm just wondering, like, why is this coming before us? This is private land. This isn't on the town common. It's not a sign. So I'm just wondering why we're involved in this project.
I thought it was because it was tantamount to a sign, but maybe the town administrator can inform me better.
We were treating it tantamount to a sign because we would want to track it through a permit. Otherwise, and I know that's not the proposal now, but otherwise, something that has limited and certainly reasonable dimensions now could grow into something much larger somehow down the line. If we kept it within the parameters of, say, treating it like a sign, then it could never be more than 32 square feet. So plus we would be able to track it. So that's why it's here. Plus the original proposal was to put it in the town easement, which we interpreted as the strip of land between the sidewalk and the road. So that was another reason to be able to bring it before the Board of Selectmen.
So there's one of these little libraries over at the church on Wattaquatic in their parking lot.
Yes, there's one next to in the church next door to the town hall as well.
Yeah, so I don't remember them coming before us. It's on private property. So I just question why we're involved in this. This is private property. It's a business. Yeah.
If the selectmen don't feel it's appropriate, then that's fine. You know, it's here
No.
because,
I actually think it is appropriate because I think, you know, you start to allow this kind of stuff and then it gets out of hand and then you can't control it because of past practice. And I don't believe that we are looking to deny anything, but I think having some small semblance of control is a good thing. And I'm all in favor of it. So this is not anything, shame on the other two that put them up without asking, you know.
no. And as I said, the original request was for the town easement, so it wasn't private property. The church next door to the town hall has it in their I guess I would call it a vestibule. So yeah, absolutely, that's private property.
Right.
Very different than a town easement. So again, it's just, you know, it's whatever the selectmen think is appropriate. In this particular case, you know, we suggested signage, the restrictions within signage because we thought it was going on a town easement, and we at least wanted to be able to have some control over it.
Yeah. No, I think it's fine, and I'm not opposed to it, and I think we should conditionally approve it. Let them get the structure built and everything else.
I'm more in Jonathan's camp where we've got two in town. They're certainly not a nuisance. Another one on private property is not going to be a problem. I don't see the selectmen adding anything. And if they proliferate all over town, Bolton's just fortunate if that's what eventually happens. So I'm kind of inclined to agree with Jonathan and say we really we don't have anything to add to this or say about it. If there's not a direct issue with town regulations, I'm fine with just letting it go.
No, I disagree. If there's one in the vestibule, that's private property. Then that's inside a structure. But I view this almost as a sign, and I think it's reasonable to have some say in it. And again, I'm not opposed to it at all. I think it's a great idea, but I think we have the situation, and perhaps we might need to more formalize it moving ahead. But I'm not opposed to having some say in the matter.
Okay, Emily.
Yeah, so one of our initial questions that kind of sparked the whole conversation was because the best accessible location was adjacent to the sidewalk, we were asking whether there were any limitations to how close to the sidewalk it could be. And obviously it would not be hanging out over the sidewalk. So that was one question. And then the second question I think Sarah and I had kind of talked about was if it would be better from a town standpoint to back it up out of the easement. And there is a walkway there that would probably need to be widened because I don't think it meets the ADA requirements. That would also be an option, but it wouldn't be as visible to the public. So those were two kind of things that we discussed, and we initially were thinking, do we bring it, further onto the property? But obviously it would be better if it could be on the sidewalk because it is more visible, it is more accessible. And if it is on the sidewalk, what our requirements are for a location in relationship to the sidewalk, I guess, offsets and things like that.
Well, so okay, I'm looking at your drawing. And if you're looking at the building from the town common, it's going to be to the right of the building, set back a few feet off the sidewalk. Is that still the location you're considering?
Yeah, just under, there's an old tree there, and it would be in that planting bed.
Yeah.
Basically, there's an existing stone wall around that tree. And it would be in there, but it would need to be close enough to the sidewalk that somebody in a wheelchair could access the box from the sidewalk.
Well, that's
if
fine.
we are to put it in that location.
Yep, just as long as it's not an obstruction to people in wheelchairs and on bicycles or with walkers or something like that.
Right.
I'm inclined to say the selectmen should just pass on this.
I
And
agree.
do we need a vote on that, Don?
I would suggest yes, just for the record.
Jonathan, would you like to make a motion?
I will. I'll make a motion that this does not fall under our jurisdiction.
I'll second that. All those in favor, say aye.
Aye.
Opposed?
I will not oppose this, but I think we need to bring this up. If there are going to be more of these things, I think we need to have some oversight of it because these things can potentially get out of hand. We've had residents who have wanted to do signs and all kinds of stuff that's gotten out of hand. I'm not saying this is, I think this is great. I think this is wonderful. But I think if there's going to be more of this, then I think that the town should have some say in the matter. But I will not oppose this right now.
Jenny, do you want to do roll call? I can't hear you, Jenny.
I sit too long. You still can't hear me?
All right, I'll do roll call. Wysocki,
Aye.
Keep,
Aye.
Sikansky, aye. All right, Sarah, Emily, thank you very much.
Good luck. Yeah, good luck with the
Sorry
business.
you had to wait a whole hour to hear that.
It's okay.
Thank you for your time.
All
You're
right, good
welcome.
night. Next is a discussion of lighting for athletic fields at Minuteman High School. Superintendent Ed Bulkillian.
Yeah, good evening. I know you're a little over time. I have a short PowerPoint. Jenny, it looks like I can share it if that would so please the board.
Sure.
Can you view that, or folks view that?
Yep.
Thanks, I appreciate the time, and I'm happy to answer any questions you might have about where we're at. But just to review, our MSBA building project is a year early, and we're on budget, actually a little under budget. In our original MSBA proposal, we had a minimal amount of money in our budget for fields, athletic fields. It was actually less than $1 million. As we've gone through the project over the last few years, and your town administrator represents Bolton on our school building committee, we realized about 6-7 months ago that we were going to have around $4 million available from our original project to put towards athletic fields. So we went out to bid on a base bid, which I'll show you. And we had a very competitive process given the times. We had great pricing. Also, due to the crisis, we have some pretty low interest rates. And we realized for a small incremental investment in lights, we'd be able to generate, we'd have the opportunity to generate greater revenue on these fields from member town communities as well as other private groups that have expressed an interest over the years in renting our facilities. So this was the base bid that went out to bid in September. We opened bids October 7th. So just to show, there's 3 synthetic fields, a multi-sport football field, a softball field, and a baseball field. And around the multi-sport synthetic field is just a simple walking track. There's no track and field on that in our base bid. And with working with our owner's project manager and our architect, we estimated prior to going out to bid that would be about $5.9 million. So we knew we only had 4, but we figured let's go out to bid and see what we got. And then we also bid alternates, which the alternates 1, 2, and 3 are lighting around all 3 fields, a competitive running track, so students and the community could have track and field events, some other equipment, and perimeter fencing around all of it, to keep pets and stuff out. And sort of manage it from a safety and health point of view. So the school committee, back in June, we looked at the resources that we had within our own school district budget to meet that $5.9 million base bid. And we had about $4 million from the MSBA building project. We had a facilities rental account. For years, we've been putting money into this from renting our facilities, and we took about $615,000 of that. And then we had a Minuteman stabilization account. The capital stabilization account was formed about 6 years ago. And the reason it was formed was we knew that the MSBA formula for furnitures, fixtures, and equipment, FF&E, was woefully inadequate when it came to equipping a state-of-the-art, high-quality career and technical high school. As a matter of fact, the formula that they use is a per-pupil formula based upon the design enrollment of the school, and it's the same for elementary school, middle school, high schools, and vocational technical schools. So that money that we'd been putting in there over the last 6 years, $200,000, $300,000 a year, we didn't need to tap into because the governor about 3 years ago came out with something called the Capital Skills Investment Program, and Minuteman has been very successful in applying for grants. We've had 4 different grants out of that program that total about $1.4 million. As a matter of fact, this past week, we're installing some logistics engineering equipment based upon that grant. So that's why the school committee voted to authorize this amount of money be set aside for the base bid prior to our going out to bid. So here you can see the 8 bids that we did receive. And there was Heimlich Construction was the low bidder at $4.4 million. Stone and Son was almost $2 million more for that base bid price. And then you can see in the yellow is sort of the cumulative amount of each alternate. And this is just a that slide again showing the cost of alternate 1, 2, and 3 is about $1 million. Alternate 4, 5, and 6 is about a little over $900,000. And this is Heimlich's bid showing the alternates. Going across each column, you'll see the additional cost of the construction budget. Then as any, sensible construction project goes, we added about 10% contingency until the end. Then we have our fees from our owner project manager, architect, and the fees from the towns of Lexington and Lincoln, because these fields would reside in both communities. But the key row in this slide is the bottom row. You can be what we had set aside in the amount. And if you see at the lower right-hand cell, there's about a $1.9 million delta between what we had set aside and what we would need to do all the alternates. And that just shows it again. We were figuring a 1.7% interest, but as I started meeting with the town managers about this several months ago, they were reporting to me interest rates more around 0.7%. So it's a pretty compelling time to borrow funds. The other thing I want to mention is that the revenue projections that were made for us by a committee of partners who may use this. Then we took that analysis and we gave it to a company called Ballard and King, who does this sort of analysis all over the country. And they had more conservative numbers than we did. So we decided to use their more conservative numbers. And they estimated that when those 3 fields were fully on board, we would be able to generate about $400,000 a year in revenue, which would go into a revolving account that would have to be used to offset the costs of this asset. So those funds that were generated could be used to pay down the debt, operations and maintenance, and also to set up a capital reserve. So we're putting aside money every year So in 10 or 12 years, when we have to replace those fields, the money's there to do that. We haven't had home fields for 4 years. So we've been spending a lot of money on field rentals ourselves and transporting our athletes to different away games. We haven't had a home game of anything in a while. And once COVID is past us all, we anticipate that these resources would make an excellent complement to the other resources in our new facility, which includes a real technical professional theater, obviously a gymnasium. We have corporate meeting rooms, a restaurant, courtyards, training areas. And when we look at what would the cost be to Bolton, right now Bolton's share of the operating capital cost is about almost 4%. So the annual amount of borrowing, that 1.2 million, would add between $8,000 and $7,000 a year to the Bolton assessment. Now the assessment will change year to year based upon the regional agreement and Bolton's share of the total enrollment of students, but that's a 4-year rolling average. So that takes sort of the spikes and dips out of the obligation of each of the member towns. The school committee did award the base bid. They didn't award any of the alternates because we had the money for the base bid. So that was awarded at the end of October. Mobilization of the three fields as part of the base bid has begun. The really not the nice thing, I guess, the fortunate thing is that Heimlich Construction has agreed to hold all the pricing on all the alternates until the middle of January. So if we borrow the money now, we know what it will cost us when we have to award that component of this bid in late January. But the fields and the lighting and all the alternates would be done by, depending on the weather, this winter, early in the fall of 2021, less than a year from now. So that concludes. I don't know if there are any questions on any of the slides. I can go back to them, but happy to answer any questions.
Yeah, I had a question. I was just looking at your numbers for engineering and architecture. We could go back to that. So I'm just wondering how you're spending $315,000 on engineering for these sports fields.
Well, Skanska is our owner's project manager. It's
Okay.
like the clerk of the works.
Mhm.
We're required by MSBA to have an owner's project manager as part of the process, and that is their fee. We've had them all throughout this process, and frankly, that's a very good price they gave us to stay with us till the end of this, the athletic field project, which was not part of their original scope. So they're on site every day. They have their own engineers and construction management folks watching over the construction project to make sure that it's happening in accord with our with the plans. They're not engineers. The engineers are hired by the architect, and the engineers, civil engineers, can actually some folks who specialize in athletic fields, those costs are inside the KBA architect fees.
Okay.
We have the same thing for the library.
Any other questions?
No. So are you, is the ask to have us agree to have our assessment up for this?
Well, there's no real vote required by the select board. I mean, we have had some member towns, the select boards have voted to endorse the project. You know, voting on what your assessment would be wouldn't be quite the right vote because your assessment will change every year based upon the number of kids from Bolton that come to Minuteman.
Oh, right. Yeah, no, I understand. It's just to vote. Right. No, I understand. It's just more of a vote of support.
Yeah.
Yeah.
Yep.
Yeah.
And if I may, and Ed, please correct me if I'm wrong, but since there is some borrowing involved, technically, well, there are two ways to approach this. One is to have a special town meeting, to have the town meeting vote on it. But we're talking about $7,000 to $8,000 increase in our assessment. We're in the middle of a pandemic, and the selectmen, if they do not call, if they vote to endorse the project and do not call for a special town meeting for this, then no special town meeting is the same as voting to approve it. So, and we've seen that in other cases for school district borrowing. So, so the ask would be that the selectmen would endorse it, and then which would be the same as not calling it for a special town meeting.
So endorse it, but not vote, or endorse and vote?
No, vote to endorse it. Vote to
Okay,
support.
well, I'm on board with this. I think it's great. I think it's fabulous. So
All right.
I'm all there.
If there are no more questions, can I have a motion?
I make a motion that we support the and endorse the ad that we're gonna have for the addition of lighting at the athletic fields at Minuteman High School.
Second.
All those in favor, please say aye.
Aye.
Aye. Jenny, give it a try.
Hear me?
Yep.
Yes.
Yeah.
Roll call, Wysocki,
Aye.
Aye.
Key.
Aye.
Thank you.
All right. Thank you.
Thanks, Ed.
Thank you.
Well,
Yeah.
thank you, folks. Hope to see you at Minuteman sometime soon.
Okay,
Yeah, I'd like
appreciate
to.
your
I
time.
need
Thank
to-
you very
I need to
much.
see the new facility. Thank you very much. It's been a pleasure.
Thank you.
Next up, an update from Department of Public Works, Randy Heglin. Randy, thanks for hanging in there.
Thank you, Mr. Chairman. Thank you. I'm not sure I'm going to do the video only because I'm having some bandwidth issues this evening.
That's
Okay.
fine.
If you can hear me okay?
Yes.
Yes.
Okay, because it's been cut. The whole meeting has been pretty much cutting in and out. So
For me as well.
All right,
okay,
Randy.
so you want to start? Go ahead, Don.
That's right. Just talk quickly before we lose you.
I guess the first thing we want to discuss is the sand pile that has been relocated back to the highway garage. I guess well, that decision was made prior to my arrival in town, and I understand it's a popular decision for it to be back. Our practice is going to be to not put a lot of material out there at any one time, and to just observe and watch the pile over time. I guess in the past has been some issues of pickup truckloads or whatever of material going out for ice control at various residences. So I mean, we're just going to watch it and see how it goes. I mean, transfer station staff has been made aware that the pile has been removed back to the highway garage, and it has been active this week. We've had a number of residents come in and taken material all week. So
just to recap for a moment, there's a mixture of salt and sand at the town highway department. It's for the use of the Bolton public. It's for private use only. The limit is on any given trip, you're allowed to have 2 5-gallon buckets. So nobody should be shoveling or loading up the back of their pickup truck or any other vehicle. And again, there have been some commercial uses of this in the past that have abused it. If that happens, we will have to reevaluate whether or not we want to continue doing this. But for the moment, the sand pile at the DPW garage has been restored.
And there's a camera on it, Randy.
That's what the sign says, yes.
Is there a camera on it?
To my knowledge, we do not have video cameras at the highway garage.
Oh, great.
Okay.
Well, I'll respect the decision that's made, but I quite honestly don't see why it's reverted back. We have had abuse. We have had abuse of that sand pile. We have had residents who are contractors who have taken that sand for use in their commercial business. I don't see the tremendous hardship that there is. You know, there is a site called weather.com that people can find out days in advance of whether there's going to be a storm, because that was one of the major issues that oh, we don't know when there's going to be a storm. Everybody knows when there's going to be a storm days in advance. So let's monitor it. But I was perfectly fine with moving it to the transfer station. It's open enough days during the week. There's enough leeway when people find out when there are storms, and they only have to go, you know, less than a quarter of a mile down further on Forbush Mill Road. But I'll respect the decision now, but I think we should monitor it. And if there's abuse, I really want it to be put back at the transfer station. Other towns have it under lock and key. And I disagree with some of the comments that I've seen on Facebook where it's our sand. No, it was purchased by the townspeople for the roads. It's not for someone that I saw on Facebook that they want to sand their 150-foot driveway. That's not the intent of the sands, but I'll respect the decision moving forward.
All right, thank you. Moving on to the vegetative management plan. Randy, do you want to introduce this? Don, do you want to introduce this? How should we proceed?
Well, the vegetative management plan is proposed as a 5-year plan. It's certainly due to be updated. It has been reviewed by Randy. It has been reviewed by Rebecca in Conservation. We have the most recent edits as of this afternoon in the most recent document that was sent out. And as the chairman correctly pointed out to me late today, the range for the 5-year plan should be 2020, 2025, since we're going to be implementing it in 2021. And Jenny's already made that edit. We just didn't send yet another version of it out. So it's been reviewed by those two departments. It's in front of the selectmen for their review. If you wanted to review and vote it tonight, that's fine. But also, if you wanted to make whatever comments you have and then make it available for we can make it available on the webpage for the public to review and comment on, and then you could finalize it at our next meeting, which I believe is January 14th. So it's really what you would like to do.
Well, I reviewed it and I'm fine with it.
I'm fine with the plan.
Yeah, I think we should give, this is the first time the public's seeing this document. I think they should get a chance to read it and give comment at our next meeting. I guess I'm wondering, in 2016, the Board of Selectmen voted not to use Roundup to manage poison ivy on the roads. And that was out of health concerns. Glyphosate, which is the main ingredient in Roundup, has been linked to non-Hodgkin's lymphoma and other cancers. The parent company Bayer has set aside $10 billion to resolve cancer lawsuits. So there's some real concerns about using Roundup. So I'm just wondering how this got on the agenda. So if we could get, some background on that, that would be good as a start. And then I would like to go through the document and make some notes of things I'd like to change.
This got on the agenda. I think we've had an initial discussion of it about, I would say late summer. I don't remember the exact month, but maybe about 4 months ago. It was requested to be, I believe that the chair requested that it be placed on the agenda. And then at the time, we said we needed to revisit this in December. And honestly, I don't remember if it was the plan need to be done in December, or if that was when we anticipated having a new DPW director on board, and that was why December was picked. But the reason it's on the agenda is that the chair asked for it to be placed on the agenda.
Right. My understanding is the vegetation management plan, the state requires the town to have one. Is that correct?
That's
Yes.
not true.
Yes.
That's not true.
Yes.
I
That's my understanding.
went to the Department of Agriculture website, and there are only a handful of towns that have this. None of our surrounding towns have a registered plan in place. I think you only need it if you're going to use herbicides. And I think practice of mowing our roadsides is, fine. I don't think we have to resort to dangerous chemicals. So we don't have to do this. This is a choice saying that we want to use herbicides to deal with vegetation instead of mechanical means like mowing.
Mr. Lowe, how much different is this plan versus the last vegetation management plan we had in the town?
Well, first of all, I'd like to say that I stand corrected, and I apologize. I did think this was required, so that was a mistake on my part. Moving on from that, there have not been substantial edits to this other than to the reference of using specific herbicides. I would certainly say that's the key point in what's changed. Aside from that, it's been pretty much just updated, but I think it is fair to say that the use of herbicides has been changed, or the type of herbicides.
Substantially or slightly?
Well, also if I may add, I think the language I added too also was to make the use of the herbicides a method of last resort. Our preference, department's preference is obviously to utilize mechanical and non-herbicidal techniques to control the vegetation. But I looked at this whole, as being new to this, the vegetation management plan, I looked at it as an additional tool in the toolbox for the Department of Public Works to be able to manage the roadside. And should we have the necessity to utilize herbicides, it gives us that ability, but it isn't, guaranteed ability, because we have to send notice through a notification process that requires us to put out notices to the board, to the administrator, the Board of Selectmen, the health, conservation,
right,
etc., and put a notice in the paper. And I also put in there that we put notices on the website. And I think my intention, or I think anybody in my chair's intention, would be to send that notice in, and that at that time would seek the input from all of the interested parties to look at and say, okay, what areas you're looking at, and gain a better understanding, rather than a general blanket approval for the utilization of the herbicides, but a specific spot area that we're having real difficulties with, and allowing them on a case-by-case basis. I mean, I was under no intention to submit a plan and say, oh, we're going to do all these roadsides. That's not our intention, and not, it would be very selective and only in areas where we would have problems. I think the select member was correct when we mentioned that we have not utilized the Roundup product for a number of years, and that was told to me by the employees of the staff of the department as well. Nate, the certified applicator, said to me, he says, I don't want to use them if I don't have to. But again, it's another tool in the toolbox that the town can utilize to do the control. And again, it's an effort of last resort is our goal.
No, I think the plan is reasonable. I think the plan is prudent. I mean, your explanation of using, certain chemical agents as a means of last resort, but at least you have that option. I'm perfectly fine with the vegetation management plan as presented.
I think it's a very good plan. I do think it's a change in the policy set forth by the selectmen. But the selectmen are not mandating the use of that chemical. They're just removing the ban on it. And I think this plan labels under very specific conditions under which it would be used.
Right.
So I will be happy to suggest that the board delay action on this, that we post it, give people a chance to see the version that the selectmen are considering, and we collect public comment on it at the next selectmen's meeting.
That's fine.
So do we want to go over the changes I'm proposing? Or we're going to do that over email?
I would suggest that let's post the plan. Let's have the public comment, and I would suggest, Mr. Keep, if you have suggestions of change, that you submit that to the town administrator, who then can
Yeah,
disseminate
they're
that
just
to others.
some I'm going to have to go over tonight then, because they're just so glaring. On page 1, there's integrated pest management. That term should be taken out of this report. That refers to insects, not plants. So second paragraph.
I think I did remove that, and I was confused too because it's actually in the CMR. I think it was originally in the second paragraph, and in the latest revision that went out, I think I had removed that with regard to the integrated pest management. 'Cause I didn't understand. I agree that I didn't understand the correlation between the pest management and herbicide management. So yeah.
Okay, and you edited that out on page 2?
Yes, I did.
Okay, then on
I think I did. I'm pretty sure I did. I tried to. If I
it's
had
still
missed it.
there. It's still there. IPM. That's for insecticides, not herbicides.
But under the Massachusetts hazardous permitting process, it's broadly considered all the same thing. So if you go get a permit, and I would insist that anybody who's applying this on town property, whether it be a town employee or a volunteer of a sports organization, that they be certified by the state of Massachusetts to apply whatever chemicals they're using. They broadly treat herbicides and pesticides under one category because you get certified in both of them at the same time. So I don't have a problem saying that we're going to be using integrated pest management in order to help with the vegetation control.
But we're not. This is a vegetation plan. This is not an insect plan.
Nobody has an insect plan.
Well, we do have a mosquito control plan. That would be IPM, but it shouldn't be in this document.
I disagree.
I disagree as well.
If we can reference the 333 CMR, which is the Code of Massachusetts Regulations, it's section 11.01 under the purpose. It's item number 1, and I'll read it. It says, ensure that an integrated pest management approach to vegetation management is utilized on all rights of way covered by 333 CMR 11.00. I think that goes back to the chairman's comment that it's kind of a generic term. I agree. Pests refers in my vernacular is going to an insect or something like that, where we're dealing with a vegetative concern. And I totally get the concern of the selectmen.
Okay, so I'll move on.
I don't have a strong feeling either way, but it's the plan was basically a carryover from several plans, as
I
we're
would
going
just
through.
look at that language because
Sure, we can do that.
plants are not considered pests. On page 3, I think we should remove using truck-mounted sprayers to deal with, to spread herbicides. So we have the motorized application equipment may be used on higher density target vegetation using the truck-mounted sprayer. The herbicide solution is applied to lightly wet and targeted plants.
I would not want to remove that.
Why? We don't have that.
Well, then there's
and
not a problem.
I know it just shouldn't be in there. That's not something we're going to be using.
Mr. Chairman, Mr. Keep had access to this document before, and it appears that both the town administrator and the DPW director did not have Mr. Keep's comments prior to this meeting. I think if we're going to be going through what I consider his request for substantial changes, they really need to be been put in writing before this meeting to allow the DPW director and the town administrator to review that at the very least.
Stan,
So I would ask that Mr. Keep provide these comments in writing, edit the document, and when we have the next meeting where we review citizens' comments, you can review your comments as well.
Stan, that wasn't the requirement on our first item this evening. You presented your changes in the meeting.
I provided those
doing the
comments
same
in
thing right
writing.
now.
I provided my comments in writing to Mr. Lowe. I provided my comments.
What does
in
that
writing to Mr.
signify?
Lowe.
We still went over them in the meeting.
Well, I don't see your edits here.
I'm making them.
All right. I don't know. You know, you can either.
This document has been cut and pasted.
Thank you. You can submit them to Don and he can go over them with Randy and they can decide whether or not the town is best served with them. Or you can sit here and, or we could sit here and go over them one by one and just decide them. But we're only going to decide them once. We're not going to decide them again in January. If we make a decision on your recommendations tonight, then we're making recommendations on your decisions, your recommendations tonight. So which way would you prefer to proceed?
Okay, I'll submit them to Don. I just, this document has been cut and pasted. It feels like it needs a lot more updating and it needs to be more specific to Bolton's needs. I don't see any scenario where we're going to be driving a truck down a road, spraying herbicides on the sides of the road.
So what we could do to help is, Jonathan, if you submit those comments, then we'll create a red line document from them so that it'll be the edits, the suggested edits will be easily reviewed at the next meeting. And I definitely do not claim to be an expert in this area, so I can't lend a lot of expertise on this. But I will say that while we definitely do not have a truck or any such vehicle that's described there, I don't know that there could never be a scenario within which we wouldn't need to bring in a contractor to do something like that. I don't know that we would, but I don't know that we wouldn't. So I think having language like that allows for a scenario if it's likely to happen. But again, I don't know if we would ever, with a contractor, ever have to approach something like that. So that's the only comment I have on that. And I really don't know if that would be necessary or not, but we will be happy to take your comments and make a red line document out of them if you like.
There are just two other general issues I'd like to bring up. One is we should, as part of the process, we should be letting the public know what roads are going to be sprayed and give them the option to deal with whatever the offending material is on their own. There is some language in there about that.
Well, I think it's only going to be applied to the rights of way of the town.
Yeah, but there's language in there about sensitive areas and allowing homeowners to deal with their frontage on their own. So it'd be something like what happened with the mosquito spray. People can opt out. So I think that's important. And then also there's another thing about mapping shallow wells that could be affected by these sprays. There's some language in here, but I want to make sure we strengthen that.
Send your comments to Don.
Okay, I will.
Any other items for the vegetation management plan? Okay.
No, I do look forward to the comments, and I appreciate it. Thank you.
All right. Thank you, Randy. Town administrator report.
Okay, thank you, Mr. Chairman. First of all, COVID-19 update. The latest numbers from the state as of this afternoon. Bolton had 6 new cases, which has our 14-day number at 13, which keeps us in the green zone or green area, green category. So that's relatively speaking positive news. You know, obviously in a perfect world, we have 0 cases and we're in the gray area, but we're doing better than many towns in the area. The FY20 MassWorks update, that's the last I'll give on that for a while. We did the most recent quarterly report and submitted to the state. Randy has now had the chance to meet our engineer. Randy will be working closely with him on some upcoming activity leading into the next update, which is the FY21 MassWorks update. As I informed the board a few days ago in an email, our FY21 MassWorks grant application was not approved by the state. And we will be seeking, both our engineer and Randy will be scheduling time with the state to get feedback on the grant application, review notes if we can get them, and regroup and decide how to try and improve the grant application so we can go back after it in the next round. So we're just kind of looking at this as an opportunity to, you know, find out, you know, if we wrote a strong grant, but there were just too many applications and not enough money, or if in this particular case, there were some holes that maybe we need to fill. So we'll take whatever feedback the state has to give us and then plan on when we submit for the next round. And which just goes to prove, you know, we can't win them all, but we win our share of them. And then finally, to beat Bob to the punch, the next virtual coffee with the town administrator is tomorrow from 8:30 to 9:30. As I always do, I'm looking forward to that. Since we've been doing it again on Zoom, we've been getting pretty good turnout. Pretty pleased with the turnout. And one thing that's not on the agenda, but this is a report that was provided to me yesterday by our assistant town clerk, Jen Marquis. Just a couple of stats that I thought you might find interesting. So with 3 weeks to go in the calendar year, our town webpage, we have seen an increase of 19% in use year over year. So with 3 weeks to go, obviously we expect to exceed 20% use. We have had in total unique page views 199,964.
Wow.
So our town webpage is being used very heavily. You might wonder what some of the top categories are that are being hit. So obviously the number one hit is the homepage. That's where everybody starts. But if you look at at the next three. The first would be Police Department. Next would be the Board of Health pages for the coronavirus updates. And then following that is the Conservation Commission. So very, very interesting to see where people are going, but we're getting substantial use. And I think it just bears out that with us being closed off and on over the course of the year due to the pandemic, the townspeople have been making significant use of the resources on the town webpage.
Great. That's good.
So I thought you would find that interesting. And unless you have any questions, that's all I have for this evening.
No, that's good. Thank you for,
One other thing relative to the pandemic, statewide, the state positivity rate has gone up to 5.7%. And when we were at our low in, what was it, August, September, I guess it would have been, we were all the way down to 0.8%.
okay, thank you. Board of Selectmen business. Are there any public service announcements?
Yes,
Nope. Wear your masks. The Boy Scouts still need the bottles and cans. Drop that off at the transfer station. If you have smoke detectors and carbon monoxide detectors, now's probably a really good time to change the batteries in them. I do that every Thanksgiving, so stay safe, everybody.
Jonathan?
I just want to recommend getting tested. I went down with my daughter to Marlboro, Donald Lynch Boulevard. The wait was not that long, and we had results in less than 24 hours. So I highly recommend getting tested, even if you don't have symptoms.
Okay. Next up is review and execute a lease renewal agreement for Bolton Access Television for the Houghton Building at 697 Main Street. Nikki Magachi. Good evening.
Hello. Look, I'm here and I'm not asking for money this time.
Yay!
Must be Christmas. I've read the lease agreement. I don't have any issues. I don't know if any of the other selectmen have any issues.
Nope, I'm fine.
Okay, can I have a motion to execute the lease renewal agreement for Bolton Access Television?
So moved.
Second.
All those in favor, please say aye.
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 Jenny, you're up.
Roll call. Can you hear me?
Yes.
Yes.
Okay. Roll call. Wysocki.
Aye.
Keep.
Aye.
Sikansky.
Aye.
Thank you.
Thank you. Thank you, Nikki.
Thanks, Nikki.
Review and execute agreement between the town of Bolton and Bolton Access Television designating Bolton Access TV, the public education and government access provider for the town. Any discussion about that?
Nope, I'll just, so moved.
Second.
Okay. All right. All in favor, say aye.
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 Wysocki.
Aye.
Keep.
Aye.
Sikansky.
Aye. Okay, thank you. Set meeting dates for 2021.
So at the end of your packet, you have proposed, or towards the end of your packet, you have proposed meeting dates for FY21, calendar 21. And I would just like to point out April, because the track that we're on, that we've been on, is the second and fourth Thursdays of the month. So if we did the second and fourth Thursdays of April, there would be the 8th and the 22nd. However, the school vacation currently is planned for the week of April 22nd. So if that was going to cause a problem for any of you, then our recommendation would be to pull the April 8th meeting into April 15th and have one meeting in the middle of the month instead of two.
Yeah, I'd be in favor of the 15th.
We had you in mind, Jonathan.
Thank you.
I'm okay with that.
That's fine.
All right, could I have a motion to accept the meeting dates with a single change to April?
So moved.
So moved. Second.
All those in favor, please say aye.
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 Nope. Come on.
Just say it. Read her lips.
You
Roll
gotta-
call. Wysocki,
Aye.
Peep,
Aye.
Sikansky.
Aye. I think you just have to project your voice a little bit.
I
No,
think it
it-
is. I wait for the little light to go around my face and then I know that you could hear me and sometimes it
It's
doesn't
the
happen.
latte you drank 5 hours ago.
Could be.
Trust me, she has no problem projecting her voice.
Any comments on the Tri-Town meeting review, the Tri-Town meeting of yesterday? Any comments?
Well, it was interesting from the fact that a good chunk of the people who were supposed to attend chose not to attend. We had no representation as a body from the school committee, although we did have perhaps 1 or 2 members of the school committee as individual citizens, and we had no members of the district administration. So if you had tuned in, all the questions originated from Lancaster, which certainly indicates that it's just not Bolton that has questions and issues that they wish to discuss. I think probably the most important of those was the EMT program and the continued inability of the district to deal with their portion of the MOU, which is the provision of a driver for the EMT cadets. We have 22 days done, 21 days left to get that accomplished.
Yeah, we would like to get it done by the end of the year.
Yes, so I've seen some of the things where everyone is supporting it, including the school committee and the district, but I believe it is in the district's court to get this accomplished. Is that not correct, Mr. Lowe?
Yeah, I'm waiting to hear back from the superintendent on a possible solution.
Okay, that's great. So I think we'll have, at least from my perspective, further comment on what is happening with Tri-Town, and you know, parents that I'm talking to in terms of getting answers to questions that they are raised. So the fact that this was a general topic, I'll reserve further comment until a more appropriate venue. But we need to advance this whole thing because we're not making a whole lot of progress at this point in time.
Yeah, I was surprised at the pushback, the perception that there were from other towns that only Bolton benefits from the cadet program. And so that's, I was surprised to hear that, but clearly we have to push back on that and do some better education there. And again, we will just have to see what happens with participation at the next meeting. I also think that the audit committee for the Neshoba Regional School District will be a substantial topic at the next Tri-Town. It is up to each town to appoint 1 member of the audit committee to oversee that to make sure that the audit of the school district is done thoroughly. That's why it's an independent committee. It's not a subcommittee of the school committee. And we'll be learning more about that at the January meeting.
At our next meeting, are we going to work with the finance committee on appointing our member?
At this point, my personal feeling, and I'm not chairing the next meeting that I know of, but my personal view is we're going to be discussing more of what the audit committee should and should not be doing so that we can find the right candidate.
Oh, yeah. No, I was referring to Bolton. Like what?
Well, yeah,
Do we
I'm not
need
sure what the
advertise for
shouldn't
that?
be doing. So
When it comes time to, yes, we would definitely advertise for it. And then it would be a joint appointment between, by advisory and the Board of Selectmen.
Okay.
I mean, it seems important to get somebody in there so they have a quorum, but
Yeah. Yeah. All right, next up is review and approve the 2021 liquor licenses. I've been asked to make sure that when we do a motion for this, that the motion be contingent upon passing inspections and receipt of insurance certificates. The alcoholic beverage licenses would be renewed for Fotini's, Neshoba Valley Winery, 100 Wattaquatic Road, Neshoba Valley Winery, 92 Wattaquatic Road, Bolton Country Cupboard, Daynouts, Bolton Bean, The International, and Twin Springs. Do I have a motion to renew the alcoholic beverage license for those firms contingent upon passing inspections and receipt of insurance certificates?
So moved.
second,
All those in favor, please say aye.
Aye.
Roll call. Wysocki,
Aye.
Keep,
aye,
Sikansky.
Aye. Next is review and approve the 2021 common vittler licenses. The eligible establishments are Colonial Candies, Bolton Bean, Subway, Great Brook Farms, Neshoba Valley Spirits, Fotini's, Classic Pizza 3, Dunkin' Donuts, Bolton Spring Farms, and Davis Farms doing business as Bolton Orchards.
so moved,
Second.
All right, contingent upon passing inspections and receipt of insurance certificates. All those in favor say aye.
Aye.
aye,
Aye.
Roll call. Wysocki,
Aye.
Keep,
aye,
Sikansky.
Aye.
Thank you.
Review and approve the 2021 Class 2 licenses. The sole establishment that needs that is Beetlebug 2. Could I have a motion?
So moved.
second,
Contingent upon passing inspections and receipt of insurance certificates. All those in favor say aye.
Aye.
Wysocki,
Aye.
Keep,
aye,
Sikansky.
Aye. Do we have, well, next up is approve payroll warrants, W21-12 and W21-12A. Do I have a motion?
So moved.
second,
All those in favor say aye.
Aye.
aye,
Yeah.
Roll call. Wysocki,
What? Aye.
Keep,
He's older, Jenny. You have to say it loudly for him.
That's right.
Keep,
aye,
Sikansky.
Aye.
I'm trying.
Do we
What was
have-
in that latte, Jenny? What was in that latte?
Do we have any minutes to approve tonight?
We do. We have 2 sets.
You'll post them?
Yes, I will. There's changes on both. Okay, the first set are the minutes of November 19th, 2020. We did change COVID-10 to COVID-19. And this area was changed to Mr. Sikansky requested the board hold a meeting on Tuesday, November 24th at 7 p.m. via Zoom to discuss these items. Mr. Keep and Mr. Wysocki both confirmed they could not attend.
They
could attend.
They could attend.
Sorry, they could attend.
No more caffeine for you.
Do you want to view the other minutes and vote them together?
Sure.
Sure.
The next set is from November 24th. Couple a misspelling of the word amended. Decisive was changed to divisive to be more accurate. And this area here was reworked. Say, Mr. Sikansky noted that the letter was sent out a day after the agenda was posted. He objected to the assertion that there was a general agreement about the need for changes and the need to form an ad hoc agreement.
Okay.
And that was it.
All right, do I have a motion to approve the minutes of November 19th and November 24th?
So moved.
Second.
All those in favor say aye.
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 Roll call, Wysocki,
Aye.
Keep,
Aye.
Sikansky.
Aye. Do I have a motion to adjourn?
So moved.
Second.
All those in favor?
Aye.
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 Roll call, Wysocki.
Aye.
Roll call, Wysocki, Keep,
Aye.
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 Good night.
All right. Thank you, Penny.
Thank
The
you,
time
everyone.
for the record is 9:46. Good night, everybody.
All
Good
right.
night.
Thank you.